All right, welcome everybody. Everyone here to learn about advanced tax and trust laws and all the crazy, boring things I deal with all the time. I'm sure you're just as excited as I am. We decided to host a series of these webinars the rest of this year, so you'll see information about that from the firm. We're just going to be picking apart little topics that we get a lot of questions on, that we hear people are concerned about, and even stuff we see in the news, what's happening in the world and how it affects things. So we'll be bringing these to you guys the rest of this year from myself, from my partner Michelle, and from Carmi, who's our certified financial planner. So just a bunch of topics. This is our first one that I wanted to kick off with. It's some information I really wanted to share on a bigger scale and get some education out about it. Just so everybody knows, I'm gonna probably go about 30 or 40 minutes just to lay this out. I am recording this, so if we can get this also captured in a way we can share with people who couldn't be here today, we're gonna try to do that. And if you know of anybody who would like a copy, let us know. Happy to do that. I went ahead and turned off everybody's microphones so that I don't get any feedback and everybody can hear me clearly. But you can send in chat messages, and all these systems have different ways of working. But if you want to find the way to send a chat, you're welcome to, and I'll monitor those as well. When I'm done with all the content and stuff, I will have time. I'll just open it up for Q&A. So write down your questions as we go, drop them in the chat, and we should have some time for that as well. So hopefully this information should be relatively new. We don't teach a lot on these topics because they don't affect our clients. They don't affect all of our clients, but as I was just telling someone yesterday, I remembered this as a young estate planning lawyer. I remember one of my mentors telling me that something you'll notice as you practice longer and longer is that you'll start to have clients that are with you for 5, 10, 15, 20 years. And as they live their life, they will continue to grow their personal net worth. And so the problems you'll be facing as a young lawyer will over time develop into newer problems as your client base grows their own personal net worth. And over the last few years, we've definitely seen that. More and more of our clients are reaching this like 2, 3, 5 million or plus in personal net worth. And so we're bringing these new kinds of strategies. They're not new to the world, they're new to our clients. We're bringing these things out more and more and more. So it felt like an appropriate time for us as we dip into the pit of summer to just get some of this info out. So what I'm not going to be doing today is I am specifically not going to be talking about your basic revocable living trust, okay? Pretty sure everybody who's on here has that in place. You guys have lived with it. You've learned how they work. You've created it. You funded it. You updated it. Hopefully, you've kept it going, and it's there as a real foundation. It's like the minimum we recommend anybody have who's going to arrange their affairs properly, especially in Arizona. From what I know from colleagues nationwide, it's pretty much the standard nationwide for a good, solid estate plan. But definitely in Arizona, it's a minimum foundation that takes probate court out of the equation, keeps you in control while you're alive and well, keeps you out of guardianship or conservatorship court if you have a medical emergency, and makes things private, maintained by your family or your chosen people, and makes it so they can manage your stuff if and when an emergency happens. And then of course, after you pass, it makes it as simple as possible to distribute your estate how you've set up. The reason, so I'm not going to cover that, but I want to just highlight a couple things that we hear over and over again as a as a misunderstanding of what a revocable living trust does. So I just want to spend a minute. A revocable living trust, it's what? It's revocable. That means you can change it anytime you want, which is kind of the whole point, right? It's yours. You do whatever you want with it. There's no restrictions on you. It's easy to make changes, and nobody's looking over your shoulder as you're living your life, right? You don't have to do a separate tax return for the revocable living trust. You don't have to report your assets and your income and your expenses to anybody. It's yours. You just keep living life like you have. But what that means, because it's revocable, is it does not give you any of the asset protection or tax strategies that other trusts might. Okay, so with all that flexibility, which you want for that foundation, you don't get asset protection and you don't get tax strategies out of it. Okay, it is there for arranging your affairs, for protecting you from probate, for keeping your estate out of probate and in the privacy of those people you've designated. Your revocable living trust also is not a tool that is built for, and I'll say this, it's not a tool that's built for, and it's a part of this category of asset protection. It's not built for that, though some of you might have a feature added. It's sort of this little plus you can add to it. But with a revocable living trust, when you pass away, your assets are distributed to whoever you name in whatever portions you name. That's the standard. It's your estate is wound up, final bills, expenses, taxes, etc., and then it's here's your check. And that check most often goes directly into that beneficiary's bank account. Once it's in their bank account, your trust, your estate, your wishes no longer control. So if they happen to be in a bankruptcy, or they happen to have creditor problems or financial problems, all those creditors, they are gonna, they can come after that. If they are married, and hopefully their marriage is in a good place, most likely what's going to happen is they'll inherit it, and that inheritance, then just by nature of marriage, it most likely ends up getting commingled in the marriage. But if that marriage ever goes bad and there's a divorce, then there's going to be an argument that it is commingled. And in that case, guess what? It's going to get split in that divorce. So an RLT by itself doesn't protect from that stuff, even for your beneficiaries. Okay, now I did say there's this little plus that some of you have added, and that is true. Some of you have something called a beneficiary protection trust, and that does add those protections for their inheritance. Okay, so if you've got a beneficiary protection trust, then in essence, the inheritance you leave them is protected from creditors. It is protected from being split in a divorce. Okay, it does carry that protection on an ongoing basis, and that's amazing. I love that tool. I love that strategy. We try to offer that. We offer that to every client, and some of you take advantage of it. Highly recommend it, because it's one of the simplest ways to give that kind of protection around some assets. We're all worried about what's happening in the world, and things feel like we're in like this seismic shift of everything. And this is one little very simple way you can say, hey, look, I'm giving you an inheritance. You can't lose it on accident. So if you get a car accident, if you get in a divorce, if you get sued by somebody, at least this piece is protected. That happens with a beneficiary protection trust, okay? And that's a piece that you can add to your revocable living trust, okay? But it has to be added. It's not default. So most trusts that we review don't have that. Okay, that's the RLT in a nutshell. What I want to talk about today is two specific things that we use for clients when there's essentially, there's not a hard and fast number, but this sort of kicks in, and really we should start thinking about it, not at a specific dollar amount. You know, I said 3 million or more, but here's kind of the metric. Start thinking about these strategies whenever you're thinking about your life and you're like, you know what, I've got this much to take care of me the rest of my life, whatever it is, right? You've got some income, you've got expenses, and you've got your nest egg. Okay, so think about that for a second. If you're sitting here and you're thinking, you know, as I really look at my personal finances and I look at my nest egg and I think about the rest of my life, am I really going to spend all this? More and more and more and more, we have conversations with clients who very, very clearly know they're not going to spend it all. They know there's going to be a decent amount left when they pass. And whatever that amount is different for every person, but you've got your, what you know you're going to spend, and you've got some amount above that that you definitely don't ever want out of reach because you're like, that's my safety net. But there's this other amount somewhere up here that you just know, even if I were to blow through all of my, my base needs and even all of my nest, like my emergency, my real safety net that makes me sleep good at night, I'll never, ever spend this. That's when we start looking at these strategies. That's when we start saying, okay, let's think about this stuff. And that's why I'm glad you guys are here, because you're thinking about it. And this might give you some context to know, what is that? This stuff is really only relevant if you have something in that category. Part of your nest egg, you just know, I'm not going to spend it. It's very unlikely I'm ever going to spend it. Maybe I'll give some of it away. Maybe I'll give some to charity. There when I go. That's what these strategies are for, okay? Historically, it was very difficult, very expensive to set up these kinds of strategies, these kinds of tools, but more and more now it's becoming less and less expensive. And so which is cool because it's more and more available to everybody. This is, these used to be only like Mark Zuckerberg would put this stuff together, or, the Rockefellers, whatever, but now anybody can think about this and see if it's worthwhile. But it's really only relevant if you're in that category. You have something in that category. How much? I don't know. It's really up to you. Is it 100 grand? Is it 10 million? It's just completely client by client. I've stopped putting artificial numbers around it because years ago, I would not tell somebody about it at first, and then later I would, and they'd go, oh, I want that, even though they might only have $500,000 in this category, right? And they'd be like, why didn't you tell me earlier? So it's just what's in that category that you think, gosh, I'm really never going to spend that. And you know what? I might be interested in figuring out how I can use that category to its best use. That's what this stuff is about. So what is it? Well, there's two main things that I'm going to talk about, two main strategies, okay? I'm going to give you just the basics of what they are, the basics of how they work, and then how they might tie together in a complete picture. And then you'll at least know, right? You'll say, okay, I get it. And again, these are two strategies out of dozens, but I think these are two that are relevant or could be relevant to a lot of people. The first one is something that my industry typically calls a dynasty trust. I mentioned a minute ago a beneficiary protection trust, okay? A beneficiary protection trust doesn't really exist until the client dies. So the client has their revocable living trust, they pass away, and if you have that beneficiary protection trust, the inheritance goes into that. It's written in your document, but it's sprung into life after you die. Their inheritance goes into that trust, and then that trust is what now holds those funds, those assets, those investments, and your beneficiaries can pull from it, right? So it just continues on for their life, and they can use it as needed, but they can't lose it. That concept, think about the beneficiary protection trust in that stage, that's kind of what a dynasty trust is, but it's set up now. Okay, it is set up now. So the first couple things to know, it is irrevocable. Once you set it up, it's written, can't change it. It does require a separate trustee. Okay, so again, like the beneficiary protection trust, you're gone, you're not the trustee anymore, it's a different trustee. It does require, or potentially require, I'll say, its own tax return because it has its own EIN and it's a different entity, it's a different legal entity than you. No, those are the three main things. It's irrevocable, it's got its own separate trustee, and a tax return. So what is it? Again, it's a trust. You decide the rules, you create it. There's a lot of options. It can be joint between you and a spouse. It can be individual, even if you're married. Sometimes that's better for tax strategies or better for asset protection. But you set it up. So you've got your dynasty trust. And you put somebody in place as trustee, cannot be you. You set up the rules, you decide how much money goes into it, and then you are hands off. Really, truly, you're hands off. You are not a beneficiary of this. Okay, so your beneficiaries are people you pick, whoever you want, your choice. Usually it might be spouse, kids, etc. Your choice. But immediately when you put money in that thing, it's not coming back to you. Okay, so this is a one-way ticket. Of course, with every legal thing, there's little nuances that might be able to do some of that, but the real path is this is a one-way street. It's going in and it's not coming back to you. Beneficiaries are your choice. Trustee is someone else. Again, you get to pick who's the trustee, but they have to be neutral. Can't be, can't be your best buddy who's just agreeing to give you all the money back. It's got to be somebody neutral. Beneficiaries are your choice. You put money in. You can put money in all at once. You can put money in a little bit at a time. You can put no money in now and put it all in later. You can, that's flexible. But you put money or property or assets or investments in there. And then your trustee will carry out the instructions you set up. So you can set up instructions as flexible as you want, but for the benefit of your beneficiaries. So I'll give you an example. Married couple, say they want to do this, and they're like, you know what, we've got X dollars in income. We're not going to, spend all of our money. We've got a couple $1 million we know we'll never spend. We have enough for us. We have enough for emergencies and contingencies, and we're just still not going to spend it all. We know there's going to be at least a couple $1 million. So let's set this up. So let's say one option to do this is a husband sets up in his own, and it's for the benefit of his spouse and children. So that's one way you could do this. Let's say that's this example. Husband sets this up and says, every dollar that goes in here is for the benefit of my spouse and children, but the distributions are not mandatory. The distributions are discretionary. So the trustee, the beneficiaries can't force money to come out, but the trustee, if they see a need, if they, they see a need and they want to make a distribution, they can make a distribution, spouse or kids. So then they set it up. They do have to get that new tax ID number, and they do have to do some annual reporting on this because it's an irrevocable trust. So you've got to do reporting. And then maybe each year they give a certain dollar amount into this trust. So why would they do that? Here's a couple of reasons. The first one, whatever you put in here is going to exempt those assets from your estate when you pass away from the estate tax. Now, the one big beautiful bill passed, and two of the things that are in there that made tax planning so much easier for me and people in my industry, is that it did set the estate tax exemption, the free amount we all get, it fixed it and then set it to increase for inflation in the future years, and it doesn't have a sunset provision where it then goes away in the future. So I've been doing this since 2000, and I mean, I started working for a firm doing this in maybe 2003, but my whole practice, there's always been a sunset provision. So it's like, okay, this is only good for the next 2 years, the next 3 years, the next 4 years, or whatever. First time ever, we have a law that says our estate tax exemption is going to keep going. Obviously, they can change that if they get together and change the law, but we're not up against a deadline on that, which is really good. So right now, the estate tax exemption this year is $13.9 million per person. Next year, it goes to 15 million, and then it'll grow by inflation, okay? Each year it'll get reset. Congress will publish that number per person. So if you're married, you get 14 times 2 or 15 times 2. So here's how it works with this trust. If you die with less than that exemption amount, then your estate pays 0 estate tax. Okay, so you don't have to do anything to get that benefit. You just get it. It's a default tax law. But if you want to give away some money while you're alive, and if you want to give away more than the annual exclusion, there's a little bit you can give away every year. But if you want to give away more than that, let's say it's this couple, they've got a couple $1 million. They just want to go ahead and get out of their estate because they don't need it. They're going to use whatever portion they give away of their exemption, okay? So if they gifted $2 million into this trust this year, then the husband would have 11.9 million of his exemption left when he dies. Of course, it's going to index for inflation, but just to show you the numbers. So that gift uses part of that lifetime amount. Here's why you do it. First, you put it in there. You've made a complete gift under property law, under the law of who owns what. Okay, you've made a completed gift. Like I said, put money into this trust, you can't get it back. So you've made a completed gift, just the same as if you gifted 100 grand to a kid or to a niece or a nephew. You gift money away, it's gone. You can't legally force it back. That's the nature and definition of a gift. Well, guess what happens when you gift legally in that way? Your creditors can't get access to it, okay? So by making that gift, the first benefit is you have wrapped asset protection around, and in this case, around that 2 million. So they're like, we don't need this much. Let's just go ahead and get it out of our estate now, because God forbid we get into a big car accident or something happens and we get sued. What we have left will be at risk, but this won't. And that's true. The Dynasty Trust acts as a asset protection trust. So that's a first reason, first benefit. The second is the estate tax benefit. So I told you, though, if they gave the 2 million, they've used up part of their lifetime exemption. So couldn't they have just left it at their death and used their exemption at their death? Yeah, it's essentially, it's close to that, except for here's the benefit. If you put $2 million into the Dynasty Trust today, and put in something that's going to grow in value, all of that growth free. So if you've got 10 years before you pass away, hopefully in 10 years, I mean, standard rules of investment, if you're investing at 7%, 10 years, the amount should double. So that's now 4 million. But it's not going to count 4 million against your estate. It only counts the original gift that you made. So all that appreciation is also exempt. That's the real key for the estate tax strategy here. again, most people in this category, you've learned how to save and invest, and your money is growing. And if that's the case, and you've got a little bit now that you think, I'm not going to need this, well, most likely you've got it invested in a way that it's going to keep growing. You're still not going to need the growth. So you get that growth out of your estate as well. And that's you catch up with the IRS on this, because the growth of your exemption amount, our free amount, that free dollar exemption is only growing by the rate of inflation. But if your investments are growing faster than inflation, you're going to cross that limit if you follow that math. So by getting some of your investments out of your estate now and let the growth happen in a dynasty trust, you preserve that future growth from impacting your estate. Okay, so then what does the trustee do? So the husband sets this up, he puts a couple million in there, says, trustee, manage these assets, invest them, and you have discretion to make distributions to my beneficiaries as needed. Great. Now hands off, trustee moves forward. Well, as this couple is living life, if they have a need, if one of the other beneficiaries has a need, they talk to the trustee and say, A, B, C, D is happening. We'd like a distribution of 100 grand or whatever it is. And the trustee has final say, but you're going to pick somebody who understands your wishes and goals and understands the dynamics. And so they're not going to be a barrier to your beneficiaries enjoying this, right? If they came in and said, hey, we want a distribution of 2 million, the trustee might say, pump the brakes a little bit. But they make a distribution and they get to take care of whatever's happening in life. Sometimes we've had clients where the trustee and the beneficiaries ask for a distribution, but then the trustee says, well, what do you really want? And they say, well, we want to help buy a house for kids or grandkids or something. Trustee's like, you know what, instead of making a distribution, because once you make a distribution, it loses that asset protection. Instead of making a distribution, why don't we in the dynasty trust just buy the house for the beneficiary and they can live there? And then it stays wrapped. Trust, but they get the benefit of the house. So you can structure things even a little bit differently than that. And why that's a big deal is because as you have assets in the dynasty trust, you can keep them in there, but still let the beneficiaries enjoy the benefit of them. What happens over time? You guys all know the power of compounding interest over long term. It just grows. And the reality is, if you set this up, and you're 70, well, maybe at 80 or 90 is when our time checks out. 30 years later, you're probably looking at the next generation. This is going to grow a lot over that 30 years. That's a big deal because guess what? Your beneficiaries would now have their own estate tax problem if they pulled everything out. So instead, you have your dynasty trust just continuing to use and monitor and grow things for their benefit so they can use it, they can benefit from it, but it's not then going to be in their estate. So they don't get an estate tax on this inheritance when they pass away. And that could be huge because over that time period, it's certainly going to grow well past what the estate tax exemption amount, what the free amount is. So keeping it in the trust is a huge benefit. So that's the general framework of a dynasty trust. Again, works very similar to a beneficiary protection trust. It just says, let's set that up now, basically. The key difference is, though, you got to put a different trustee in place, and you're going to have to be dealing with some accounting and tax return issues each year as that goes. So those two things are sometimes, realistically, like a big enough hurdle. It's like, nope, don't want to deal with it. Those usually are the two biggest hurdles in all reality. But you have to know about those before you even consider this. But if those two things are like, I don't know, that's kind of interesting, I might still be willing to do it, then those are usually the only two biggest hurdles. After that, it's just a matter of how do you want it designed, how do you want it built, Who do you want to be the trustee, etc. So that's a dynasty trust. Okay. The next thing that I want to talk about is something a little bit. It's called a family limited partnership. And I'm not talking it in the context of an operating business, right? We're not talking about setting up, buying a yogurt shop and going into partnership with our family. Family limited partnerships have been used for a long, long, long time, just for the purpose of, I shouldn't say just, but for the purpose of managing a family's money. So most people live life and they, buy a house, they start saving in their 401k, maybe an IRA, maybe a Roth, maybe a brokerage account, maybe they buy rentals, whatever, right? They build their wealth and save in those pretty standard ways. You get to start having some wealth that, has the ability to take care of you completely just on the growth or the income or the interest produced by your own wealth. The managing of the money is now a job, right? And that's a transition going from I'm working my job at work to produce the money I need to live to now my money is producing the money I need to live. That's what a lot of people have used family limited partnerships for, is they take all of their various things and instead of, just having accounts in all of these names or in my revocable living trust name, they have them all or some of them owned by a family business, a family limited partnership. And then the family limited partnership is now essentially a business of managing your money. How is it set up? Two key factors. There has to be a general partner, and then there are limited partners. Okay. The general partner, they're the person in charge. They call all the shots. They decide basically everything, right? They're like the CEO or president of a company. It's also very similar to a trustee of a trust. They make the decisions about how things are invested. They make the decisions about when the partnership will distribute any of its profit to the partners, right? I mean, some of you are invested in companies that pay dividends. You get those dividend checks quarterly, right? Those public companies, they have a whole committee that looks at their finances and decides, okay, how did we do this quarter? Are we going to declare a dividend? Yes, we are. It's this much there. And they send out all the checks or they wire the funds out. Those are dividends. In partnerships, it's just called a distribution, but it's the same process. So the general partner is the one who's going to look at how the company's done over the last quarter, year, and decide if any of the partners get a distribution based on their ownership percentages. So it's just like a company, you're going to have all these slices of ownerships. And there you go. If the general partner declares that we're going to make a distribution, everybody gets a pro rata share. So who are the limited partners? Well, most of the time, when you first set this up, the reality is you are essentially sitting in both spots. Okay, you and your spouse, whatever. You're the general partner and you're the limited partner. And you structure it like that because you're like, I don't want to give any of my money away. Great. You're the general partner, you're the limited partner, perfect. So as general partner, you have all the benefits, and as limited partner, you just get distributions if and when they are made. The general partner is allowed to own whatever percentage of the company. The limited partners are allowed to own whatever percentage, but the whole is only 100%. So it's split between all the partners. Whether you're a general or limited, it's split in whatever portion you agree. So it's just like a company, but the general partner is the one who's really the decision maker. how people use this is, like I said, they take their various investments, their various, maybe rental properties or businesses, investment accounts, things like that, and they consolidate them into the name of their family limited partnership. And the general structure is, you say the general partner owns 1% of the company and the limited partners own 99% of the company. The reason you do that because in partnership law, just whether it's this kind of partnership or somebody's actually in business and it's a partnership, the reason is because the general partner is the one who is personally liable if the partnership ever has problems. So, this typically doesn't happen in family limited partnerships, but if you think about a limited partnership that maybe was set up to build an apartment building or something, they'll have a general partner and they'll have 99.99% limited partners. The general partner's on the hook if something goes wrong, at least as to their 1% share. Okay. The limited partners, they are basically immune from liability. They are protected from liability because they're called limited partners. So limited partner is the one who's in a great spot because they don't have liability, which also means as these clients start to stick assets into this structure, guess what? They can asset protect 99% of it, which is a really cool thing to do because, hey, we all want to be protected from potential lawsuits. We all want to be protected from getting in trouble with, even scam lawsuits out there, right? Protecting your assets requires it to have a limited partnership component. So that's how they're typically set up. And usually, again, you own the whole thing. But then where the strategies come in is instead, if you want to start making gifts and getting some of these assets just into the hands of your beneficiaries or out of your estate for estate tax purposes, like we talked a minute ago, if you didn't have a limited partnership set up, you might think, okay, I'll give away, some cash. I'll give away some of my stock. I'll maybe give a house. And you've got all these things you can give away, but it's sort of one at a time. It's a piece of this, a piece of that. But if you don't want to start splitting things up like that, the family limited partnership instead, you can give away shares. So any percentage share of the whole can be given, and then you don't have to sell a piece of real estate if you still want to keep it. You don't have to liquidate the stock. You don't have to get rid of the cash. You can just gift shares to whoever you want. And then those shares, you're only giving limited partnership shares, but those shares they now own, but they only own the share. Okay, so they only own that percent, whatever is given to them. In Arizona and most states, if a limited partner owns a share of a partnership and they get into a lawsuit and they lose, their share can't be taken by the creditor. Okay, the creditor can't take it. All the creditor can do is get something called a charging order, which is an order from the court that says, hey, and it's an order to the partnership that says, hey, partnership, we have a judgment against this person who owns a piece of this partnership. We have a judgment against them. If you ever declare a distribution of profit, it has to go equally to all partners or, in their proportionate ownership shares. If you ever declare a distribution and a distribution is going to go to this person who got in financial trouble, you're not allowed to give it to the person. You have to give it to the creditor. Okay, so it's a charging order. Arizona limits the remedy, so it's just a charging order. They can't step in and become a limited partner of your family limited partnership. That's important for a bunch of reasons, because it maintains control of the partnership with you, with the people you want. So family members, if you gave that to a family member. But guess what? The general partner is not the one, I'm sorry, the general partner is still the one who gets to decide if a distribution is ever going to get made. Well, if that happens to one of the limited partners and they've got a charging order against them, the general partner can say, oh, I see you have a charging order. I guess I'm not going to make distributions this year because I don't want it going to your creditor. And they can reinvest distributions into their, that was kind of funny. Sorry about that. They can reinvest into partnership assets or hold on to the cash. They can do whatever they want with it as long as it stays in the partnership. And then there is no creditor attaching your inheritances. Oops. So that's how a limited partnership works. Okay. Now, limited partnership and dynasty trust, they have unique tax consequences. Cover them briefly. So the first thing to know about both of them is that the IRS doesn't tax them in the way that they could. And that's what was nice about the one big beautiful bill, is that we got this clarified. It's going to stay, and we don't have to worry about in the future. Partnerships, they have to file a 1065 every year. They're going to issue the owners a K1 for distributions or profit of the partnership. Okay, so some of you may get a K1 from some of your investments or things like that. A dynasty trust actually doesn't file a tax return, but it does have to report income to the grantor, which is usually the client, the person setting it up. And then the grantor reports it on their own individual tax return. So if the dynasty trust generates income, it gets reported to the grantor and taxed at individual tax rates, which is phenomenal because trust tax rates are much higher. So both of these strategies have really, they do not typically increase the tax burden on you today. Like there's no extra income taxes on you today by doing this. It's pretty neutral, okay? That's rare when it comes to strategies that allow you to do asset protection and estate tax planning. So it's pretty neutral. How they work together, generally speaking, you've got your RLT, which is going to hold everything to begin with. And then you're going to set up, you could set up one or both of these. Usually the first thing is going to be the dynasty trust and maybe the family limited partnership next. You can start putting some of your assets in here. You do not put IRAs, annuities, Roth, you do not put those in there. So brokerage accounts, real estate, investment properties, things like that. And you just manage it, at least at first, as a general partner for yourself, for your benefit, your spouse's benefit, etc. You have this dynasty trust set up over here empty. And that's how they're all set up at first. Set it up so you've got the bucket ready. As you do more math and you do more analysis of your personal financial net worth and you realize I'm really never going to spend all this, usually what most people are doing is they're gifting shares of the limited partnership shares to their dynasty trust. I drew that arrow wrong. Actually goes from you, from your trust to the dynasty trust as you gift limited partnership shares. You can give 1%, you can give 10%, you can give 50%, you can give whatever percent you want. You can give 100% or 99%. You can do it incrementally, a little bit at a time every year. But that's generally how it's set up. And where you get extra fuel on this strategy is each time you gift shares, you're generally not giving all 99% at once. Okay, generally you're doing it in tranches, 5%, 1%, 8%, 12%. each time you do that, you're giving less than the whole. And the One Big Beautiful Bill also gave us another gift, which said that these gifts of minority interests, okay, so you're giving a minority interest in the partnership, are allowed to be discounted when you make the gift. So if you give somebody $1 million, the value of that gift is $1 million, and $1 million is going to come off of your lifetime exemption. But if you give them 10% of a partnership that's worth $10 million, right? That's still $1 million, isn't it? No, because you get to discount it. And depending on how everything works out, maybe you can discount it 10%, 20%, 30%. But the value of the gift is going to be discounted by some additional percentage, which means you use less of your lifetime exemption amount. So it's pretty cool because you can kind of cram down gifts instead of giving somebody $1 million or giving it, right? You cram it down into the setup and you only use 10, 20, 30% less than that actual gift amount. So all of this stuff is now set, we're ready to go with the One Big Beautiful Bill, and it's not going away from anything we can see. The last couple of years has been very, very questionable. So I went a little longer than I wanted to, but that's okay. These are the two big things I just wanted to get everybody aware of. They're definitely not relevant for most of my clients, but they're relevant for a few. And that's really why I wanted to bring this out, because more and more people are asking about these things, and I don't want you to miss this information. So we can do Q&A. Give me a second to change some of the settings here. Oh, I did see a question come in. Are you saying that the Dynasty Trust is the investment to protect assets outside of what I need to use for my retirement? Yes, it absolutely can be. That's one of the uses of it, is to protect assets that you don't need for retirement. So, all right, you guys now have permission to turn on your microphone. You're welcome to pop a question into the chat or just turn your microphone on and tell me what your questions are. This is Q&A time.
Hey, Francisco, I'll ask the first question, kind of break the ice, if you're all right with that.
Absolutely, man.
Okay, so, and again, I'm not highly educated on these matters, so I may ask novice questions along the way here, but what I'm kind of focused on for this session for me is I have some real estate, and what I wanted to do was in retirement, not retired yet, but in retired, I wanted to manage that. In other words, they're under an LLC. I'm thinking I want to go further with that. I'm not sure the partnership thing would work well with that, but I'm looking to protect those assets as best as I possibly can. Possibly do something with your suggestion on the retirement side of things to kind of maybe that Dynasty Trust would play well with me. I'd have to investigate that further with you. But I'm thinking of that. But I'm thinking along the lines of, should I be thinking about, like, should I create an S Corp to manage and maintain what properties I do have? It's not a large estate, but things like that, asset protection, and then being an employee of, are those other things that you think are worth looking at, or maybe should I be more focused on what you got here?
So it always depends, right? The first, so one of the other webinars I'm going to do, I don't know which date off the top of my head, but might be more relevant for what you're talking about with asset protection for things like rental properties. I'm going to do one whole session on that.
Okay.
Rental properties, residential rentals have so many well-established strategies that this isn't specifically designed for that. Essentially, what I drew earlier when it was, a whole bunch of little houses and bank accounts, et cetera, and all of that going into a family limited partnership. What you're talking about is going to look more like not a whole bunch of little houses and things, but it's going to be all of your LLCs if you have multiple pieces of real estate, but then that whole thing being wrapped by a limited partnership. So that this would kind of be that next step. For clients that have a lot of rentals, our first recommendation is get the best insurance policy you can to cover all kinds of liability.
Yeah.
And then start setting up your LLCs and your property management company as a separate company, and then manage rentals through, like, if you're going to manage them yourself. That's sort of the step by step on that. And then this would be coming in after that, so that essentially you've got one company that does have a bunch of assets, but those assets happen to be LLCs.
Okay.
So then you've got that one top level entity.
Yeah. So like a 2-tier LLC strategy is right.
Yeah. Yep.
So what would be, it may be the wrong question to ask for this form, and if so, just let me know. I like what you're saying, but what's the difference? Why wouldn't I use an S corp versus as an LLC, or is that more complicated and take a little too long to answer?
Well, it's a yes and no. I'll give you the quick answer. So LLCs can be S corps. So S corp isn't anything different than an LLC. It's the way you may or may not choose for your LLC to be taxed, to qualify under different tax rules for federal taxation purposes. So rental real estate portfolios, oftentimes it's not very advantageous to set those up as S corps, but a lot can go into that conversation. It might be a good idea, it might not be a good idea, but I would just put that first thought in your mind, that you typically will have an LLC, or not typically, you'll have an LLC, but then you'll choose whether to have it taxed as an S corp or not, and that's a tax choice with the IRS. So it'll still be an LLC.
All right, cool. Thank you, sir.
Yeah, man, you bet. Got a question on chat. In a dynasty trust, can you change the beneficiary? Great question. Yeah, there actually are a couple ways to do it. So you set it up, you say, here's who my beneficiaries are. You also build into it 2 safety factors. One of them is you create inside of it the role of a trust protector who has whatever ability you give the role, the ability to maybe potentially change beneficiaries. The second thing you can do is, but you can't be that trust protector, of course. Again, it's a neutral, etc. The other thing that can go in there is sometimes called a power of appointment. And it's essentially saying, I reserve the power to, I create the trust, here it is, it's going, but I retain the power to appoint these assets when I die in a different arrangement. So there's limited ways, there's broader ways, they all have different tax consequences, so you got to be very careful how that's designed, but you can retain some ability to adjust beneficiaries, yes. Next question was, underlying issue is, how can you essentially keep a family vacation house within the family for generations? If you don't know, yeah, family vacation homes. The way family vacation homes work is a little bit more like a business. So we've done a few of these, and we've seen them go year by year by year by year. And essentially what you're doing is you're essentially creating a partnership among the family members, and then deciding this can only stay in the bloodline, right? Or maybe you include spouses or something. And you put together the rules of operation, the rules of how often people will get to use it, the rules of when we need money to do repairs and upgrades, how are we going to request that capital, and things like that, and maintenance. Who's going to be paying for and managing the maintenance of this thing. Most of that is done in some kind. The ones that we've done inside a family limited liability company, very similar to an FLP, where in the business operating agreement, we lay out all these painful details. The reason I say we've only done a couple of them is because we've been asked to do a lot of them, but as soon as we start asking people to make decisions and agree on these things, there's no agreement. And so, we can't document it if there's not an agreement. Because usually, actually, in all the circumstances, people come to us after, the grandparent who bought it, they've passed away, and the family's like, okay, we want to make this a generational family vacation home, but then they can't agree on what the rules are. If you're the buyer of the family vacation home, you can set it up as part of your plan. This is a family vacation home, and here's the rules. And then you just set up the rules. So that would be a way to do it for a family vacation home. Good questions. Good questions. Yeah, any question works, guys, because this might be the first time you're hearing about all this stuff, and that's why I'm trying to just give it to you in a real high level. Here's kind of how they work. Here's how they're set up. Here's how they're used. There's a million nuances with this stuff. So fire away if you've got them. If not, we got just a couple minutes before the hour's up. I do want to mention that let's see, yeah, that we've got lots of emails are going to be coming out, not lots, but emails for future topics on these webinars. So join them as they're relevant. When we have the way to deliver recordings, if you want recordings, let us know. If something in the topics that I talked about today, you're like, I'm not sure if that's relevant, it might not be. I mean, the reality is, again, this has to be with a certain amount of money that you're not going to spend. And you want to be a little bit more proactive about what happens with it instead of just dropping it all at your death. If there's any of you that are like, no, this feels relevant, I just don't know how it would apply to me, then all I say is get on my calendar. Let's have a 15-minute conversation. I can probably help you think it through and at least give you an initial, this isn't what you need. You can just do this in your trust, or you can just do this, gifting or something like that. I can probably in like 15 minutes tell you, maybe this feels relevant, and we can talk about what the next step is. There's no decisions on this stuff ever made quickly because they are rather complicated. And before I do anything like this for anybody, I want them to understand the pros, the cons, what's it going to look like after it's set up, what are you going to have to do on an ongoing basis. None of this stuff is like, and forget it. So there's no snap decisions here. It's a real process of learning how this would work. Would it work for you? What's the consequence financially, tax-wise, life-wise, etc. And then only when you get way down that road of just investigation do you then say, oh, this actually feels like it solves something I'm concerned about. So if you want to have a quick call with me, you're welcome to. That's part of the benefit of coming here, is I'm going to give you that link. So in the chat box, I just posted my calendar link, so you can grab that. Just click on it, find a time that works for you. It'll give you my openings automatically, so I won't have any conflicts. It'll schedule you for a quick call. We'll talk and see, if it makes sense. It like I said, most people, it's not right on for them. But for those of you that are like, I don't know, maybe, let's at least keep the conversation going, because procrastination, as you all know, is the biggest evil of this stuff. And putting it off and putting it off and putting it off is where people end up in trouble. So it's an easy, quick step to just at least keep the ball rolling so you don't stop thinking about it. All right, with that, I thank you guys for coming. Thank you for the questions. And next Thursday morning at 9 o'clock, I believe, Michelle is doing her webinar on a more introductory topic, like what we did not do today, but why to even use a trust. So if you're interested in that, look for the emails, or you can email our team. We'll get you registered. All right, guys, great to see everybody. Have a great afternoon. Stay cool out there.
Thanks.